Well, hello everyone. I'm Professor David Cantor, and as Director of the Refugee Law Initiative, it's my great pleasure to welcome you to the 12th Annual Refugee Law Initiative Seminar Series, run in partnership this year with the University of London Refugee Law Clinic. This series of 6 webinars delves into the topic of asylum after COVID-19, looking at the UK's new plan for immigration in global context. Our objective is to interrogate how, as the global COVID-19 pandemic begins to slow, states and other actors are re-engaging with the issue of asylum. Each session in this series thus evaluates distinct aspects of the UK's so-called new plan for immigration. We do so in detail and also by putting it in the context of broader global trends. In this third session, titled Moving the Goalposts, brackets, yet again, we look at how the new plan for immigration impacts specifically on access to justice in the UK asylum system. Put in the global context, over the past 2 decades, we've seen a number of countries adopt increasingly stringent measures to limit access to asylum procedures. In this regard, the UK, despite having one of the most developed justice systems in the world, trials ever more draconian restrictions on access to justice for refugees. The new plan for immigration and the 2021 Nationality and Borders Bill again push that restrictive agenda, with reheated ideas about limiting access to justice in the UK asylum system. This seminar asks at what point a common law system like the UK will decide that we've reached legal breaking point. Specifically, we inquire to what extent do restrictions on access to the asylum system constitute a denial of access to justice itself for those seeking asylum? How have similar proposals in the UK and elsewhere fared previously in terms of legality and implementation? And rather than restricting access, in what practical ways might asylum systems such as that in the UK actually be improved in the pursuit of fairness and efficiency? To help us understand these proposals and their implications for the UK and for the global refugee regime, we are truly fortunate to be joined today by 4 expert discussants. I'll introduce them in turn before they speak. The format of the seminar, though, starts with a presentation from a refugee law clinic volunteer describing the main pertinent features of the proposed new measures in the UK's 2021 Nationality and Borders Bill and the new plan for immigration. Each of our 4 panellists will then briefly present their initial thoughts on a particular aspect of those proposals. After that, we're going to open to a wider discussion format where panellists can engage with one another and with questions and comments from other participants in the session. During the initial presentations by panellists then, please do feel free to pose your questions by typing them into the chat box. Finally, please do keep your microphones on mute and your videos off unless you're a presenter. We will also be recording this session, the podcast of which should be available in the coming weeks on the RLI website. So without further ado, let me turn to our first speaker. I'm truly delighted to introduce Kelly Frevely, who is an associate at Clifford Chance, a law firm partner in our refugee law clinic where Kelly volunteers. Kelly will introduce some of the main clauses of the 2021 bill that address access to justice for asylum seekers. Over to you, Kelly.
Thank you, David. So as David has mentioned, this afternoon's session is going to cover the UK government's new plan for immigration and the potential effect that it will have on asylum seekers in the UK and their access to justice. I'm going to briefly summarize some key points of this plan for anybody who's new to the debate, and then, as David has mentioned, our speakers will provide their thoughts regarding the impact of this plan. So the new plan for immigration started out as a policy paper that ran in consultation from the 24th of March 2020 to the 6th of May 2021. The plan had the following 3 objectives: to increase the fairness and efficacy of the UK's asylum system so that the UK government can better protect and support those in genuine need of asylum, to deter illegal entry into the UK with the hopes of reducing criminal trafficking, and to remove people in the UK that the government deemed had no right to be there. As a result of the feedback that was received in response to this consultation paper, the Nationality and Borders Bill was announced in May 2021. The bill is currently being reviewed by the House of Commons and is expected to be reviewed by the House of Lords early next year, with implementation as early as next summer. Some of the changes to the asylum system that are going to be included in the bill, which our speakers will touch upon today, are as follows. The bill proposes to create a new criminal offense with a maximum sentence of 4 years for anyone who arrives without entry clearance into the UK. Someone who enters unlawfully and overstays is covered by this, as well as anybody who helps asylum seekers, even if they do not benefit from doing so. Also, the bill proposes to introduce externalization, which is the concept that the UK may not be the best place for the asylum seeker, and that if the Home Office deems another location safe for the individual asylum seeker, they should be sent there as opposed to remain in the UK, even if the asylum seeker has never been to this other country, as long as the Home Office deems it as safe for the individual asylum seeker. The bill also proposes to change the appeals process to remove certain stages of appeals and certain fast tracking of certain cases, as well as introducing a new test for assessing age, in which an asylum seeker would be considered over 18 if his or her appearance and demeanor very strongly suggested that they were significantly over 18. Finally, and probably the biggest change, is the change of admissibility criteria to a two-tier system, which assesses asylum seekers based on how they arrived in the UK, as opposed to the reasons why they've arrived, as well as penalizing asylum seekers who arrived to the UK via irregular means. While the UK government believes that this plan will make the immigration process in the UK more fair, a number of organizations have raised serious concerns about the new plan, including the UNHCR, which published its own legal analysis on this issue that argues that the bill actually undermines the UN 1951 Refugee Convention, which asserts that a refugee should not be returned to a country where they face serious threats to life or freedom. I hope that this summary was useful to contextualize today's debate, and I'll turn it over to our speakers who will discuss further key issues surrounding this topic.
Excellent. Many thanks indeed, Kelly. We turn now to our first of the invited speakers, and I'm delighted to give the floor to Shiona York, who is the solicitor at the Kent Law Clinic, which deals by and large with asylum and migration cases. This is at the University of Kent. Shiona is going to be talking to us about key ongoing structural issues in access to justice for asylum seekers in the UK context. Over to you, Shiona. You need to unmute.
Yeah, sorry. Thank you so much. I'm just going to put, is that showing? Is it showing properly? No. Very sorry.
Yep.
It is showing properly. Is that right? Can you all see that screen? I wanted to speak about two aspects of structural issues impeding access to justice. And one of them are some of the things that are in the Nationality and Borders Bill. And the other is what I deem to be completely fundamental, which is the placing of the burden of proof on the applicant. Just staying with the Nationality and Borders Bill, there are two aspects to this. First, what I call re-legislating, and I use that term to mean performative measures which have been passed in legislation before to achieve a certain effect. And though they failed, 10, 20 years later, we see the same kind of legislation repeated. And so this is probably the third time, or maybe even the fourth time in UK law, that asylum applications purported to be determined on the basis of how the person arrives, what they say when they first get here, how soon they tell their story. In other words, factors which are nothing to do with the definition of what makes a genuine asylum claim. And I've put on here, I mean, a couple of these are what Kelly has mentioned, the differential treatment of asylum seekers according to how they arrive, but treatment, provision of accommodation and support on that basis, making a claim at a particular place, all these things have been suggested by the Labour government under David Blunkett in 2002, and even before that under Thatcher. So we see a whole suite of measures which are unlikely to be successful, even in the government's own terms, and are quite likely not to be implemented, but they're there to make a noise and to appease people who are frightened of a few people landing on beaches. The second thing that the bill does, and I expect the UNHCR speaker is going to be speaking on this, is the bill purports to change how the UN Convention on Refugees must be interpreted. A unilateral change that would be, because it's accepted that the convention is interpreted in different jurisdictions around the world in a way which attempts to keep the same interpretations in certainly different common law jurisdictions. And in particular, moving the standard of proof to the balance of probabilities away from real risk and anxious scrutiny is bound to make a big difference to all asylum claims, and defining particular social group in requiring both the innate characteristic and the distinct identity as perceived in the rest of that society to be necessary for somebody to win such a claim. So those are the things that I would highlight about the Nationality and Borders Bill. So we have a suite of measures of re-legislating, and we have a purported attempt to change how an international convention is going to operate without having the political honesty of simply saying to Parliament, we want to derogate from the Refugee Convention because, and then having a big wide public debate about that. They obviously would fear such a debate. The second fundamental problem in UK asylum and in fact in immigration determination is the placing of the burden of proof on the applicant. And we all know that in refugee law, that is hedged about by a lot of supporting ideas, such as recognising how difficult it is for an asylum seeker to prove their claim, as is set out in the UNHCR handbook. But this placing the burden of proof on the applicant is what anchors the culture of disbelief in UK immigration and asylum law. And we see in lots of context how this moves the standard of proof from even the balance of probabilities almost to a point of the criminal standard of beyond all reasonable doubt. And that's going to be entrenched by these changes in the bill, but is fundamental to the problems faced by really any migrant in this country. The attacks on appeal rights and the attacks on legal aid are also pieces of re-legislating, but what I would draw attention to more is the erosion of legal aid, even where it's ostensibly available to asylum seekers, to a point where it's very difficult, even for mainstream asylum seekers, to get legal aid and therefore get their case properly prepared. Thank you.
Excellent. Many thanks indeed, Shiona. I think it's very useful to start off with the points that you've really highlighted, really the range of ways in which provisions of this bill do seek to limit access to justice for asylum seekers in the United Kingdom. And very helpful also the point that many of these provisions have previously been put before Parliament and adopted in some form or another and been found very difficult to implement. So I think that provides us with a great jumping off point for our next speaker, who is Professor Nick Gill from the Department of Human Geography of the University of Exeter. Professor Gill will be speaking to us, putting this UK case study, if you like, in the comparative context of his research on asylum systems in Europe and beyond. So over to you, Professor Gill.
Thank you, David. There are different models of legal aid provision in Europe linked to the evolution of legal systems and the development of welfare systems in different countries. These give rise to variations in the level of centralisation of legal aid systems, their independence from the state, and their relationship to courts. My research involves in-person observations of asylum appeal hearings in multiple European countries, with a focus on legal experiences and procedures rather than legal aid per se, and I'll be presenting comparative insights from these observations. Our belief is that by being at court and seeing processes firsthand, we can gain valuable bottom-up insights into legal systems, and I'm going to make 3 points. My first observation is that many of the challenges in the UK are shared in Europe. The speeding up of appeals is a common theme, for instance. Since 2016, a common story has been the intensification of pressure to decide asylum cases quickly. In Italy, the removal of a whole level of review was approved in 2017. In France, legislation was introduced in 2018 that reduced the window of time asylum seekers have to claim asylum and to file for legal aid. This legislation also reduced the number of appeals heard in person and by panels, so increasing the number on paper. Judges commonly hear 13 cases a day in Paris. In Belgium, we saw one judge blister through 9 cases within an hour, including shouting at the appellants and legal representatives and cutting them off mid-sentence. The requirement to be rapid is unequally distributed though. Deadlines for submitting appeals are as low as 48 hours in border procedures in France. Germany has a 14-day limit in the regular procedure, but 7 days in the unfounded, inadmissible, Dublin and fast-track processes, and 3 in the border procedure. Deadlines to decide appeals, on the other hand, are much less numerous, poorly applied, and usually much longer. Second point, again common across Europe, the squeeze in asylum protections means that the state casts a long shadow over justice in this area of law, despite its vested interest in refusing applications. Initial decisions are terribly under-resourced in many European countries, for instance, and during our fieldwork we encountered countless examples of translation, typographical and clerical errors, keeping unnecessary pressure on appeal mechanisms. Automatic voice recognition software was commonly used in some countries, including Germany, to produce transcripts, but poorly checked. Low pay and long hours characterize the work of lawyers in the asylum field in Europe, resulting in shortages of qualified lawyers and legal deserts in various countries, as well as the UK. This can result in desperate actions. Some lawyers demand cash for appellants on the day of their hearing. One German lawyer, and that was in Germany, one German lawyer got up exactly 2 hours into the hearing, declaring that he had not been paid for more time and left the speechless appellant to fight the rest of their case alone. Some lawyers in Italy make deals with accommodation providers who show asylum seeker residents lists of approved lawyers they can choose from, thereby cornering the market. So-called street lawyers also operate in Italy around railway stations, trying to turn appellants against their existing lawyers by blaming them for processing delays. They then take large sums of money and typically advise appellants to say nothing at their appeals so as not to contradict their initial interviews, resulting in perfunctory and impotent appeals of only a few minutes in length. There are question marks over the independence of asylum lawyers in some places too. In Austria, for example, we were told that asylum seekers who need legal aid are given vouchers that they can only redeem with government lawyers, while government funding to support NGOs and independent legal advisors to provide legal advice and representation to asylum seekers, including appellants, has been discontinued. Thirdly and finally, there are nevertheless some positives to take from Europe, and we could be doing more to have international dialogue. Austrian higher courts overturned deadline reductions, and in France, pressure from civil society, including strikes, helped to resist deadline reductions for appealing. Some countries still produce full transcripts of asylum hearings and check them with appellants too, reducing misunderstandings and making onward appeal easier. In general, more internationally comparative conversations would be a good way to share both common challenges faced in Europe and beyond, as well as positive practices.
Fantastic. Many thanks, Professor Gill, for your intervention. And I think there are a number of really key points that stood out for me listening to you speak about your research in this area, which has been long and I know very broad in scope. Certainly do have a look at Nick's profile. There are a range of publications that I highly recommend to you. One of the key points you made is that in some ways, the UK's new plan isn't an outlier, that similar sorts of things do seem to be going on in Europe. But that isn't much of a reassurance given the degree of variation, the poor implementation of these measures and the impact that they eventually have. I did like your positive ending note, which is, these measures can be resisted, and, the efforts that have been made, Refugee Law Initiative interventions, those of other civil society bodies in front of Parliament, and of course, through law clinics like Shiona's and ours, do offer a way to try and challenge some of these measures. And I think it's important to keep that in mind. I'd like to turn now to our third speaker. I'm really delighted to welcome Dr. Ruth Brittle, who's a lecturer at the Law School in Nottingham Trent University. Of course, these kinds of proposals in law impact differently on different profiles of asylum seekers. And Dr. Brittle will be telling us about her research on age assessments for minors and the implications of changes proposed by the new plan, particularly for minors who seek asylum. Over to you, Dr. Brittle.
Lovely, thank you, David. Now, what we're engaging with in terms of what's in the bill is set out in clauses 48 to 56, if anybody wants to look it up. It's significantly been increased since the bill was first introduced and been amended under the current reading of the bill through Parliament. I just want to go back to what was said in the new plan for immigration, and what the Home Secretary wanted was a robust approach to age assessment to ensure acting swiftly as possible to safeguard against adults claiming to be children, and to use new scientific methods to improve abilities to accurately assess age. What this suggests, and what the gripe of the Home Secretary appears to be, is that there is widespread abuse of the system by adults claiming to be children who are arriving on our shores, claiming to be unaccompanied asylum-seeking children, and also that under the current system, age is not accurately assessed, or in other words, the Secretary of State doesn't like some of the decisions that are made by either social services or in fact the Home Office itself. And this really kind of it adds to what Shona was saying in terms of the culture of disbelief, that children who look 18 are lying when they say that they're not 18. And in my research, I mean, one of the things that I would like to highlight is the fact that the Home Secretary hasn't provided any evidence to prove that there's widespread abuse of this system. And there's plenty of research available to show that children who are undertaking these journeys will age through the journey, will look older, and that we have different approaches to age chronologically and developmentally, depending where you come from the world. So to say that there's one form of age assessment, which is what the Home Secretary implies in her in the bill that's now been put forward, and that a scientific method will solve this is frankly disingenuous. I agree that accurate age determination is important, and I think this is something that ought to be highlighted, because that will determine where the young person and the child will receive education, healthcare, social services, and support throughout the asylum process. And I just want to highlight a couple of points that have been put into the bill that I think are flagging concerns for anybody that works with children and young people, and will add to the trauma that they already undergo having to go through this procedure. Best interests, which is a duty and a safeguarding duty that the Home Secretary must follow, is not mentioned anywhere. It wasn't mentioned in the new plan. It hasn't been mentioned in the bill, but of course Section 55 of the Borders, Citizenship, Immigration Act is still in existence, so she still has a safeguarding duty. Clause 49 and 50 refer to age assessments being made by a designated person. Now, under the original plan, there was talk of a national age assessment board, but it seems to have come back down to one person who will oversee both the local authority age assessment process and will also be the person that the Secretary of State will refer age assessments to. This goes against the guidance that the Association of Directors of Children's Services have published, and goes against any of the guidance that the UNHCR, the Committee on the Rights of the Child have published, that the better way of dealing with age assessments is a multidisciplinary board or group of experts who can look at different aspects of a child's cultural and environmental factors which impact on their age, their looks, their demeanour, etc. And then the introduction of the scientific test. Now, UK has been an outlier in the sense that we don't have scientific tests currently. They're not approved in any of the age assessment process, unless you think that, I mean, some people would argue that looking at their physical appearance and demeanour is scientific of a sort. But the plan is to introduce the imaging technology, so X-rays, DNA testing, all of which have been condemned by the Royal College of Paediatricians and Child Health, as well as the British Dental Association, for being unethical and inappropriate for children. And the Committee on the Rights of the Child has said all states should refrain from using such methods. So there have been a number of cases that have come before the Committee on the Rights of the Child involving scientific tests, particularly against Spain, Belgium and Denmark, where such medical and scientific methods were condemned. And then just finally, the last thing I just want to highlight is consent. There's obviously, we're dealing with children under the age of 18. They've got to consent to these scientific methods. If they don't, that'll be an issue of credibility. And that for me is a very disturbing amendment that's been made to the bill. I'll leave it there, and obviously I'll answer any questions that anybody will raise afterwards. Thank you.
Excellent. Many thanks indeed, Dr. Brittle. And I think that's a particularly chilling point on which you end there, which is the not only questions about legality that we often enter into in these seminars, but a really strongly ethical point there about forced consent, which I think has real moral implications in terms of what the bill is trying to do in relation to potentially very vulnerable asylum-seeking children. Thank you very much for sharing your research. Again, you can find Dr. Brittle's research on this area by following her profile on the website. This brings us to our final speaker, and it is a real pleasure to welcome Professor Gillian Trigg, who is the Assistant High Commissioner for Refugees of the UN Refugee Agency, the Office of the High Commissioner for Refugees. She's going to be sharing with us some reflections on how countries outside the UK particularly have made use of procedural devices such as admissibility criteria to adjust or restrict access to asylum systems. It's a real pleasure to have you with us, Assistant High Commissioner. Over to you.
Well, thank you very much. And it's a great pleasure to be with you and to hear your different perspectives on the international legal obligation to ensure everyone has the right of access to a proper legal process to make their claim for asylum. And thank you all very much for your work. Of course, it's interesting to have these reflections because this is the 70th anniversary of the Refugee Convention. While I think it has saved millions of lives over 7 decades, it's probably subject to some of the most profound attacks now on its normative provisions that we've seen in its 70 years. And that's immensely troubling. Well, you've asked the question, what about elsewhere? What about the rest of the world? And in a way, I can't restrain from noting that I've just come back from Niger, one of the poorest, the second most poor country in the world. And there they have open borders, open access to asylum, and an asylum system which struggles, admittedly, but nonetheless is operating within the principles of the Refugee Convention. So it's very disturbing, of course, to understand the substantive content of the proposals that are being made to the UK law, and we've made our position very, very clear, and that is that to the extent that they do not protect the right to claim asylum and to do so within the principles of the rule of law and due process, then that is a breach of the international obligations under the Refugee Convention. But another answer, and a more precise one to your question, is that admissibility concepts, mechanisms for denying access through some form of procedural requirement, is actually very limited in other parts of the world. And that is, again, why it's so distressing, so disappointing, at least for us, to see that the very countries that crafted the Refugee Convention in 1951 are now countries that, in Europe in particular, and parts of North America also, starting to retreat from those principles with highly technical and complex provisions, which not only in the spirit, but in the letter of the law of the Refugee Convention are being denied. So firstly, relatively few countries adopt these provisions. And you've mentioned, I think, the EU directive or the EU position. And they do have limitations on the right of applications. They deny a right to consider or to have a claim considered where an EU member state's already granted protection. Pretty clear. Where they've had protection in a first country of asylum, or where they could have sought protection in a so-called safe third country. But in essence, the EU ensures that those procedural requirements are subject to very stringent procedural safeguards to protect the right to claim asylum. And of course, there's a right to rebut the presumption of safety in another country and a right of appeal against any inadmissibility decisions. At base then, as far as UNHCR is concerned, there may be admissibility procedural devices, but they must be done in a way which safeguards the fundamental right to claim asylum. And that's really where we stand. I'd like to make, just if I may, very briefly, to dispel some of these misinformation perhaps. And that is that something like 86% of those who are displaced outside their country seeking asylum or in need of international protection are hosted by poor or developing and middle income countries in their own region, 73% in neighboring countries. Iran and Pakistan, of course, host 2.3 million Afghans. Turkey hosts 3.5 million Syrians. 1 in 8 people in Lebanon is a refugee, and 1 in 14 in Jordan. So in making this point, what I'm attempting to say is that the response by the United Kingdom appears to be grossly disproportionate to the nature of the problem. And it's also a problem not only in relation to the Refugee Convention itself, but to the spirit and letter of the Global Compact on Refugees, which speaks of equitable sharing of the responsibilities and burdens of refugees. A critical legal point: refugees are not obliged as a matter of law to seek international protection at the first opportunity. If they were required to do so, and given the fact that most are hosted in neighboring countries, we would not have an international asylum system at all. We would simply have a system in which the neighboring country is bound to host. There are many reasons why someone might choose a second country and an onward movement. Family, cultural links, language, religion are all reasons that in law are acceptable as a basis for moving on. Of course, you're all familiar with Article 31 of the Refugee Convention that prohibits the penalization of someone on account of the means of entry. And we've had that discussion from others, that it is quite contrary to the convention to make a distinction on the basis of the mechanism of arrival. And we've seen that, unfortunately, in a number of countries. So perhaps I can conclude by saying that UNHCR advocates for a fast and fair procedure. In other words, we're not, we hope, putting obstacles in the way of an efficient and fair system. We want to propose and advocate a fair and fast system which makes a quick decision, which also facilitates returns of those who are not in need of international protection. In other words, if you can't do the latter, the asylum system itself really falls apart. We do ask that where there are compelling reasons not to admit a claim for asylum, that there be a reasonable opportunity for readmission to a country that will in fact allow that asylum. And perhaps importantly, we'd like to have countries to explore other regular mechanisms, legal pathways, education, labour mobility, community sponsorship, and very particularly family reunion, and a more flexible and humane approach to family reunion criteria, particularly in the United Kingdom. So thank you very much for the opportunity to be part of this. We would really then like to emphasize that the asylum system is not broken, as claimed within the United Kingdom. It in fact is a very effective system that's been working reasonably well for 7 decades. And we do ask that countries like the United Kingdom look to fair and fast systems, and we think that will be a better way of resolving the problems that they perceive to exist than in delaying and using these very sophisticated legal techniques to deny applications. So thank you very much, and back to you, David.
Thank you very much, Professor True. I'd just like to draw out a number of the points there. I mean, I think putting the UK in its global context is an incredibly useful exercise. I mean, firstly, the point that I'd like to draw on about the relatively small number of asylum claims that are in fact lodged in the United Kingdom, and the relatively small population of refugees that we host is, I think, an absolutely key point when we think about what is a government trying to achieve by reconfiguring an asylum system in the way that's being done here. Secondly, I was pleased that we were able to kind of extend beyond Europe and think about what kinds of procedures exist in other parts of the world where many other countries, non-European, non-North American, do have asylum systems, do determine refugee status. And it was really, I think, crucial to hear the point that very few of those countries rely on procedural mechanisms such as the unfair admissibility criteria, or the unfair way in which admissibility criteria are often used. So I'm really grateful to you for joining us to present UNHCR's perspective on this and putting forward those absolutely crucial points. I think that we must have reached an end of year lethargy, as there doesn't seem to be any questions as yet from our wider audience in the chat box. So if I can encourage those who are online to have a think about the questions that you would like to ask our speakers. I can see that a number of things are starting to pop up already. This is a really unique opportunity. We've got 4 people who are real experts on the inside workings of asylum systems and questions about justice and fairness within them. So please do take advantage of this. Whilst you're gathering your thoughts, I thought I might just very quickly run through a question that I have for the panelists, which perhaps speaks to one of the kind of the larger points behind this. When we talk about an asylum system and whether it's functioning effectively, I think it raises questions about the kinds of provisions that are being proposed in the new plan for immigration, in the Nationality and Borders Bill. To what extent, based on our experience, do we think that they will in fact make the system work either more efficiently or actually end up having the desired end that the government appears to be pursuing here? It seems to me that there may well be questions on both of those points. So whilst we're gathering a couple of other questions, I wonder if I can very quickly ask for a kind of 2-minute response from each of our speakers on that. Nick, I can see you're, Professor Gill, I can see you're raring to go. So I'm going to start with you and then I'll go to Shiona and follow.
Thanks, David. I think that's a really important point about the effectiveness of the system, because I think it's really important to diversify the means by which we assess an effective system, and in particular to include the voices and experiences of asylum seekers who've gone through that system when we're designing asylum systems. That's really the point that I wanted to make, but it's really surprising how little kind of consultation with the experts by experience who've been through that process, the government and governments in Europe as well undertake before they put in place quite sweeping changes. So that's what I'd really like to say to your point.
Thanks. That's a very concise and to the point response. I should say that the very final session of this webinar series is in fact run by a visiting fellow at the Refugee Law Initiative, Amar Bajboj, Dr. Amar Bajboj, who is a Syrian refugee and works with the Syrian refugee community, and we'll be gathering a number of prominent thinkers from that community to talk through what should a new plan on immigration or asylum really look like in the UK. So hopefully you can join us for that and hear what comes from that particular quarter. Shiona, over to you. You'll need to unmute.
Yeah, two things on this. In the 2007 to 2011, there was the new asylum model and the Solihull early advice pilot. And that showed that if you gave time for asylum seekers to collect their evidence, you made sure they were working with lawyers, you had a little bit more of a shared burden of proof, a bit more cooperation with the Home Office, and you aimed at getting right first time decisions, then there was an improvement in the whole system. And it's interesting that that was sidelined, because when they did the final evaluation of that, the Home Office didn't include the fact that there were fewer appeals and there was less money spent on asylum support and all that kind of thing. They just looked very narrowly and said, that's too expensive. We can't have caseworkers working all the way through and all that kind of thing. So I think we already know, and it's almost, I'm not disagreeing with you, Nick, about getting the lived experience of asylum seekers, but I think anyone who's worked in the system as a lawyer, anyone who's worked in the legal aid system will know that what you need is time at the beginning of the case. The asylum seekers need it, and you need it to prepare their case properly. And in this, it's saying that those who are deemed to fit the bill of expedited appeals, a maximum of 7 hours is going to be spent on preparing the case. If you can interview a nervous or vulnerable woman complaining about a sex-based persecution in 7 hours, well, you're a hero, because I've never managed it. I think the other thing about the effectiveness of any of the measures in the new plan is they are completely fanciful, because they are fundamentally all predicated on the possibility of removing or deporting the people who don't fit not just asylum law, but also immigration laws as well. And given that the UK is incapable of removing or deporting more than a few thousand people a year, and this is something that's gone on for 20 years, it is fanciful and simply foolish to base a policy on being able to get rid of people. You have to base your policy on being able to assist them to live here in the most dignified and fruitful way they possibly can, and maybe remove a few of the most horrible, but not to attempt to remove them all. And so I think the effectiveness, I mean, when my colleague Richard Warren and I sent a submission to the new plan, one of the things we were talking about is probably not a single measure in there was based on evidence. Not one single measure was based on what people actually know about the motivations of claiming asylum or how the system actually works. Yeah.
Thanks a lot, Shiona. On that very last point, it brought a slightly wry smile to my face when I was reading the Hansard report of some of the debates, and I forget which member of Parliament it was, posed the question to the Tory minister, the government minister, and said, what is it that the minister knows that UNHCR, Refugee Law Initiative, about 30 other organisations and research institutions don't know? And I think it was exactly that point of evidence that it's very much lacking. It's not a data-driven policy. And your earlier point about it being a false economy, I think is also an important one when we start talking about budget, which politically in the UK is important. Thanks, Ruth. Can I tease you out on a minute or two on that?
Yes, just very quickly. So, I mean, a bit like Shona, looking at what the evidence is, because this is predicated on widespread abuse of the age assessment process, that, you know, lots of people are claiming to be children when they're actually adults. In fact, I think the figures for last year, well, it was 2019, 2020, show that 6% out of all the unaccompanied asylum-seeking children who claimed asylum were found to be adults. So it's a much lower figure than the Home Office claim in their new plan. But yeah, I mean, in terms of the effectiveness, what this seems to bring in is a new layer of this designated person deciding whether or not the person is the age the local authority have assessed that person to be. And the local authority already, all local authorities, and I know mistakes are made, but all local authorities follow very careful guidance that has been put together by experts on children and on assessing age, which is much more robust than the system that obviously the immigration officer at the port might use, which is the appearance and demeanour test. And I'm slightly worried, I didn't mention it in my talk, but I'm slightly worried about this idea of the abbreviated age assessment process, which might be introduced under the regulations, and whether that's a fast track age assessment process. I suspect that'll only be based on appearance and demeanour and won't be based on other evidence. And like Shona says, you know, in age assessments as well, you've got to get together all the evidence, you've got to understand the background, the environmental considerations, the you know, the cultural aspects before you can truly assess a person's age. And I say it seems to, in terms of cost, if we're talking about cost, I can't see this saving an awful lot of cost. It's more to do with these high profile cases where children are coming in with beards and moustaches, and the press are going, oh look, these are adults, they're over the age of 18, and not actually having any understanding of what these children have been through and where they've come from. So I think I can't see where the proposals are actually going to make things more efficient, other than giving the Home Secretary a level of control over how the local authorities have assessed it, and bringing in this abbreviated age assessment process.
Thanks, Dr. Brittle. I mean, it sounds like as in so many of the other areas, when we come to, you know, the most vulnerable children amongst them, that, you know, we're dealing with a situation of if it ain't broke, don't fix it. On that happy note, Assistant High Commissioner.
Well, thank you. And if the central question is how effective are these asylum systems, I'm always astonished by how much money some governments pay to set up, to redraft legislation, to find every basis for denying access, offshore processing, externalization of the obligation, all of which does not solve the problem, makes it far worse, creates endless misery for people, but also endless misery for governments, because ultimately they have to deal with it through the courts that get clogged up, and it's extremely expensive to do it. It will be far better to face the problem, or from their perspective, more directly, to acknowledge what the legal rights are, to embrace them quickly with a fair and legal process, and to return as quickly as is possible. But one of the problems is that because justice delayed, of course, is justice denied, but it also means that people who have not got an answer within years simply can't be sent back for practical reasons. And this is one, wherever I go on mission, I get the same complaint from countries, particularly frontline countries, which the United Kingdom, by the way, is not. But they often say, we have a system, we have a fair system, but when we've completed it, we can't return. And that brings me to the key point I wanted to make. And it's a little bit beyond our mandate at UNHCR, but what we're starting to advocate for is to look at the whole system of migration and the movement of people in a more complete way, in a more holistic way. Because one of the allegations, often completely unfair and without evidence, but sometimes fair, is that asylum systems are being abused because there are not proper legal pathways for people to come to the country. And one of the greatest challenges for us is this confusion and conflation of those who are migrants and those who are in need of international protection as refugees. We are now increasingly saying, why don't states look to improve the legal pathways through migration to offer people who want to improve their life opportunities, but to do so in a way that doesn't make them victims within an asylum system where they don't really belong. And that's why, as I said in my introductory remarks, we are very keen to see the development of community sponsorship, family reunion, labour mobility for ageing European societies that desperately need people with skills in the care, health services, and of course in agriculture and construction. And we see that all over the world. So I think our plea is, why would a government expend so much time, energy on inefficient and expensive processes when it would be far more efficient to look at regular pathways and fair and fast systems that identify those in need as quickly as possible. And we hope that that eventually some governments will see some sense in this. But I perhaps have to conclude by acknowledging that here we all are trying to understand a policy in a rational, legal and data-based way. Now, this is not, in fact, a legal issue anymore. It's a highly politicized issue used by political leaders, sadly, for their own advantage. And that is really the great struggle. What we need, of course, is to empower and encourage political leaders to see this in a more efficient and effective way, evidence-based, and to develop policy accordingly. So thank you very much indeed. Back to you, David.
Thanks very much, Professor Triggs, and it's a very powerful message. We've got a few questions which have appeared in the chat, and I think we can give our speakers a kind of quick 2 minutes to pick one of those questions possibly and respond to it. I suppose just Professor Triggs, responding to what you've said, I guess the $1 million question is, okay, how do we do it politically? How do we allow politicians to make that leap? And perhaps that may be something you'd like to come back to at the very end. Shona, you've had a number of questions in the chat, and we may have to extend our time by 5 or so minutes, but can I ask you in sort of 2 or 3 minutes to pick one, or possibly very quickly 2 of those questions to respond to?
Okay, I'm looking at number 2 here. How likely do you think the courts might push back against the interpretive provisions in the bill? And I think the scholars in the audience are going to laugh, and the jurists in the audience are going to laugh even harder, because here's my potted summary, which is that there'll be many quick refusals by the Home Office, and they will go to the Immigration Tribunal, and there'll be quite a lot of very rough justice judgments where judges say things like, this person has lied, or they've done this, or they've done that. There might be a few brave decisions in the upper tribunal, and then 1 or 2 of these cases will go to the Court of Appeal, which is a bit like the attack dog of the UK legal system, where you'll get somebody like, I don't know, Lord Justice Laws or somebody like that, who will say, nonsense, the bill says this, the Act says this is how we're going to interpret it. Obviously, a lot of people are complaining that this violates the Refugee Convention, but Parliament is sovereign and this is what we're going to do. And then someone will go to the Supreme Court, and there will be some very weak judgment which will say, oh, the Home Office should perhaps improve its guidance slightly because, the best interests of the child haven't been featured in this guidance. So I'm not hopeful, I would say. And I would say this is a political question, which is why I said that at the beginning, and I think Dr. Ziegler's commented on this, about the government not having the political courage, not having the political honesty to say, we'd like to derogate from the UN Convention because it's forcing us to take too many people. And then there would have been a wider political debate on what Britain's role should be. Instead of trotting out the thing about Britain welcomes refugees, well, we don't. We absolutely don't. And it's not really been discussed for a very long time at that level. So I don't think the courts are going to be able to do anything about this if it's in primary legislation. It'll take the same form as the way Article 8 has been put into primary legislation, the public interest criteria in the Nationality, Immigration and Asylum Act, which is causing a lot of hardship to migrants. it will be the same as that, and it will have to be challenged politically and change. The law will have to change.
Thanks a lot, Shiona. Nick?
Thank you. Yeah, so really interesting discussion. I want to come back to this question of resistance and effectiveness. In my research, we saw judges being fantastic a lot of the time, trying to push back against the system at a very low level in terms of the courts that they were presiding over. We saw lawyers being fantastic as well, but the thing that wears them down is the repetition and the pace of the work, which can lead to burnout, and it can lead to kind of secondary trauma as well in some cases. So what we need, I think, is more international cooperation. We're seeing the courts deliver more judgments internationally, but I think a softer conversation that's perhaps not legal, but is more a kind of socio or social science research footing that brings some of the actors together to talk about the ways that they have to approach their work could be quite productive. I know the efforts of the International Association of Refugee Law Judges to do something similar to that. And I'd encourage that sort of work, just to create international fora so that the poorer countries perhaps can provide a kind of counterpoint to some of the work that's being done in the developed world. Yeah, just to reiterate the point about delay as well, one of the things that we really saw applicants struggling with was waiting for years for their hearings to take place, not just in terms of mental health challenges, but also in terms of just forgetting what had happened by the time their hearing came around. It's much more likely that you're going to contradict yourself and be inconsistent if you've had to wait 2 years for your appeal than if you did it within a couple of months. And then finally, a question in the chat from someone who's an expert in Hong Kong about how to communicate beyond the technical and the legal. And I think that's probably what I'll leave you with, is how important it is to involve a large number of people in this conversation, not just the very legally minded, and to have a broad conversation that's open to the non legally technical experts as well.
Thanks very much indeed, Prof. Gill, and nice to end with a really intriguing proposal like that. Dr. Brittle?
Yeah, I think there was a question in the chat about cross-border advocacy and the kind of encouraging that, and I think Siôn and Nick have touched upon that in terms of this is a highly political issue, and the only way really to I suppose battle against it at the minute is looking at it on a more global level. I mean, from the child's rights perspective, I mean, there's a lot done, but at I suppose a quiet level, if you like, with the Committee on the Rights of the Child, that this has been something that they've looked at quite extensively a few years ago, and produced a joint general comment with the Committee on Migrant Workers, and did a very comprehensive look at age assessments within that, and how they should be approached. But also, there are other, levels, and I know Nick mentioned the International Refugee Law Judges group, which has again done good work in terms of how to deal with children within the system. And I would just like to finish on that question of delay is being an access to justice issue within age assessments. That's a real problem, as often children end up aging out by the time their appeal is heard, by the time they get to the first tier tribunal or the upper tribunal, and then the question becomes almost academic and doesn't really help the person who's in the middle of all this. And one of the issues, obviously, that the Home Secretary has put forward is this concept of efficiency, but we need to have more belief in the experts, and the experts that that already deal with these kind of cases day in, day out. Thank you.
It is a stunning example of justice delayed being justice denied. Thank you very much, Dr. Brittle. For the final word, I'd like to pass over to Professor Triggs.
Well, thank you very much indeed. And I think perhaps the question I've been asked to respond to is how do we promote that leadership? if we are dealing in such a highly politicized environment, how do we encourage that that political willingness to take on something that may be inconsistent with the views of others? One of the things that we're trying to do in the UN Refugee Agency is to really taking on the spirit of the Refugee Compact, which is to engage civil society much more strongly. And one is through the Interparliamentary Union, which you will all be very familiar with. That it's really been remarkable to work with parliamentarians who are not members of cabinet, but who are nonetheless influential with their own constituents and who can influence at least the views of cabinet. And I think that they work quite well globally. They meet, they compare policies, they are evidence-based, but of course have a political foundation, but using groups like that to inform them and to get them on board can help. Another that we're seeing is proving to be very effective is working with mayors and local governments, because in fact, of course, they're the ones that actually deal with this on a daily basis. They're the first responders, if we can use that phrase. And again, they are working remarkably well together to try to get policies that are maybe quite different from those that are given by federal or central governments. And we see some opportunities there. I think the chat also asks, what about offshore externalization, which there's, of course, there's a lot of talk about now, and we're very concerned about it. And the immediate answer is that there is no acceptable model that we know of in relation to offshore externalizing sources. Australia, of course, being a particular example, that the safeguards are simply not in place. The United States also effectively externalizes by under the MPP program, and the Title 42 in effect are means of pushing back and pushing that responsibility back to other countries. But before we become too obsessed with this question of externalization, which of course we reject without the safeguards in place, we have to, I think it has to be acknowledged that those countries that are currently searching for partners for externalization, Denmark and the United Kingdom, haven't found partners. So in the end, you have to pick your battles, and if they can't find partners, then it's demonstrable that and it's demeaning to countries, particularly of Africa, where they're being approached to take the asylum claimants from Denmark and from the United Kingdom. They're responding, as many of you will have seen, the African Union has responded very robustly. And indeed, of course, in our own advocacy, we've made it very clear that without very good safeguards at every stage of the process, offshoring is not going to be an acceptable outcome. We've also been asked about how we deal with generalized violence, famine. There's of course always the opportunity for prima facie recognition, which does happen and is accorded without looking at individual cases. And that's a very humane way and efficient way of reaching an answer in relation to people who are fleeing a particular dispute. We look at Mozambique, for example, people going across national boundaries to Tanzania in particular. Of course, the Syrians going into parts of the Middle East. Similarly, the Rohingya leaving Myanmar for Bangladesh. So there are ways of dealing with these generalized violence situations. Perhaps I should finish by saying one thing we do need to give some thought to is the impact on climate change on the displacement of people. Now, it's not a direct line. Most people are displaced across national boundaries because of conflict, but climate change is increasingly leading to conflict, which in turn leads to displacement internally and then ultimately to displacement across national boundaries. So we see the impacts of climate change, particularly in the Sahel, Burkina Faso, Niger, and Mali, as being particularly vulnerable at a massively increased rate, where their countries are really being decimated by desertification. So can I finish on one point? And that is, firstly, I really appreciate the reference to international cooperation, of course, to the role of the International Association of Immigration Refugee Judges. They're a wonderful group, and I think we need to support them and work with them. And you as scholars, of course, play a very strong role in supporting their work. I think that helps a lot because they are influential and they are developing jurisprudence that's applying globally and is very, very useful. But can I finish by saying, I think the stories are really important. We do need to get to a wider public. For me to talk about Article 31 of the Refugee Convention in most contexts has no impact whatsoever. We have to tell the stories. You have to talk about the 13-year-old girl and what happens to her when she tries to find safety and is abused, etc. along the way. You have to engage with people at very personal level. And of course, for those of you who are working in the daily practice of refugee law, you have plenty of stories. But I think that's the way to engage hearts as well as minds. But we've got to get out to that wider community, and that brings me back then finally to the Global Compact, which is the point of the Compact was to engage, of course, governments, the private sector, but faith-based groups, academics, scholars, judges, parliamentarians. But we have to get the justice of the claim and the importance of the principles of asylum to that much wider public, to enable to empower our own politicians to be a little more courageous and less vulnerable to populist politics. So thank you all very much, and back to you, David.
Well, many thanks, Professor Triggs, and I think that that's a very apt point on which to end, drawing out this relationship between politics on the one hand and justice, and perhaps this is where they start to overlap. Thanks everybody who's submitted additional comments and questions in the chat. I hope we've managed to touch on most, if not all of them. It's been an excellent discussion. And I'd like to just draw proceedings to a close now by expressing my very great thanks to colleagues at the RLI, Kelly from the Refugee Law Clinic, our 4 fantastic presenters today, and also to all of those who've put in questions in the chat or just joined us to think about and learn a bit more about this issue about access to justice in the asylum context. We really look forward to seeing each and every one of you again for the 4th seminar in this series, which is on asylum and illegality, protecting refugees or criminalising asylum seeking. That's the next seminar in the series. It takes place on Wednesday, 12th of January at the very same time. All of the details about that are on our website. Until then, just remains for me to say thanks again, happy winter holidays and a good new year, and goodbye everybody.
Thank you, thank you, thank you.